Hi, everybody. Bill Prince here, and we're going to finish up Week 7 material with a discussion of real property and land use control, which is the subject matter of Chapter 26 of your text this week. When we talk about real property, we're talking about land and things that are attached to land. And when we talk about the ownership of real property, we're talking about owning it from the middle of the earth below to the heavens above. So when we talk about real property, we're talking about land, and land includes the soil of the surface of the earth on that land, all of the water and mineral rights that might be contained under the land, most of the airspace above the surface. Of course, we know that the federal government regulates, airspace in terms of airplanes and things like that, and so we have to be careful about flying our drones and that sort of thing. Real property can also include fixtures, which are things that are permanently attached to the property. So things like houses and in some cases, mobile homes can be considered as a fixture, which is an improvement to the land. It also includes plant life and vegetation, so things like crops that are intentionally planted there, and other trees and plants that may occur there naturally. The owner of real property can encumber one or more of his or her real property rights, and a subsequent purchaser or an assignee of that realty will typically take the realty subject to the pre-existing encumbrances. So, for example, if I have a plot of land upon which there is oil, and I have leased the oil rights to Exxon, who in turn has put some pumps on that land. If I later go and sell that land, Exxon would continue to have the ability to pump that oil, even though somebody else now owns that property. There are a whole bunch of different ways that property can be owned. Again, like most of the other topics in this course, real property forms the subject of an entire semester class in law school. And so again, we can just hit the highlights. But the absolute best type of ownership that one can have in terms of the Cadillac or the Mercedes of ownership is what's known as a fee simple absolute. And under a fee simple absolute, that's an ownership in real property that affords the owner the greatest possible aggregation of rights, privileges, and powers. Only an individual and his heirs can hold a fee simple absolute. So that's a piece of property. There's no encumbrances on it. There's nothing that's going to spring or shift. There's nobody else has ownership interest. It is owned by that individual. There's also what's known as fee simple defeasible, and that's an ownership interest in real property that can revert to the grantor of an interest upon the occurrence or non-occurrence of a specified event. So, in the old days, back when bars and taverns weren't particularly well thought of as well thought of as they are today, sometimes you would see deeds where a piece of property would be conveyed to an individual, but then there would be some language that would say so long as never used as a bar or tavern. So and in that event, then the property would go back to the original owner. So that's what's known as a fee simple defeasible, that somebody has absolute ownership in that property and can do basically whatever they want with it, unless they build a bar or tavern, in which case title would revert back to the original seller. There's also a lesser known interest in property called life estates. And life estates is where somebody holds a piece of property for their life or the life of another. And so, for example, I might convey a piece of property to my son, and that piece of property would remain in my son's hands until he were to pass away, in which case the property would go to somebody else. So a life estate is an interest in real property that that affords the holder of all rights of possession and use of the land, but exists only for the duration of the life of some person and only to the extent that the life tenant does not cause waste. So, for example, if I conveyed my home to my son for his life, while he could occupy it and use it, he would not be allowed to tear it down, burn it down, things of that nature. There's also ways to for more than one person to own a piece of property, and there's what's known as tenancy in common. So, for example, myself and my cousin might want to go in and buy some investment property. So he and I could purchase a factory location, and and so the factory would deed the property to me and cousin as tenants in common. And basically, what that means is that we each own an undivided interest in the whole property. So it's not like he owns half and I own half, but we each own the entire property together. That's what's known as tenancy in common. There's also what's known as, and now the significance of tenancy in common has to do with what happens if one of us wants to sell the property or if one of us dies. There's also what's known as joint tenancy, and joint tenancy is joint ownership of the property in which each co-owner owns an undivided interest or share in the whole property. The thing about joint tenancy is that if one joint tenant dies or passes away, then that property would automatically pass to the surviving tenant. So you often see joint tenancy put together in estate plans and trusts and things of that nature. There's also what's known as tenancy by the entirety, which is a unique joint tenancy which exists only between husband and wife, and there neither party can transfer his or her interest in the property without the other's consent, and in the event that one of the spouses passes away, the property would automatically pass to the surviving spouse without worrying about estate planning or wills or things of that nature. There's also what's known as community property, and community property is rather rare in this country. There's only a few community property states that exist, but community property is joint ownership of property by a husband and wife in which each spouse owns one half of the interest of property acquired during the marriage. So any kind of marriage property acquired during the marriage may well be community property, and the other spouse is entitled to half of that. All right. You can also create what are known as leasehold estates, where somebody doesn't actually own the property itself, but owns an interest in the property. And so a lease is a contract by which the owner of real property grants to a person an exclusive right to use and possess the property, usually for a specific period of time in return for rent or some other form of consideration. So, for example, if I have an extra house out there, I may not want to sell that property, but I want somebody to occupy it. So I may agree to allow somebody to come onto those premises and live there and occupy it, again, in exchange for rent. And again, it could be a month-to-month lease where they pay me every month, or it could be a yearly lease where they have the option to be there for a year. A leasehold estate is an estate in real property held by a tenant under a lease, giving the tenant a qualified right to possess that land. There's what's known as a fixed-term tenancy, and again, that would be I would lease my rental property to the tenant for a year, say, and then at the end of the year, unless we come up with some other arrangements, that individual would need to leave. There's what's known as a periodic tenancy, where I rent it to somebody month to month, for example. I can give 30 days notice that I want him out, or he can give 30 days notice that he doesn't want to renew. But until that's done, it would just continue month to month under the same terms. There's what's known as a tenancy at will, which is a leasehold estate, which permits either the lessor or lessee to terminate the tenancy without cause and without notice. And then there's what's known as tenancy at sufferance, which is a nice way of saying you got squatters or freeloaders hanging on your property, and that's a situation that arises when a tenant continues to occupy the real property after his leasehold has expired. And many times you have to go to court to get those individuals out of there. There's also what are known as non-possessory interests in property, and these are interests in the property that you don't possess it, but you take some benefit from it. So in some cases we have what are called easements, and easements are non-possessory rights to use another property another's property in a manner established by an express or implied agreement. So many times we'll see easements. For example, utility companies or power companies will need to contract with landowners to be able to put up poles or cell towers or things like that on people's property. Those are easements. There's also what's known as profits, which again, I may have some agricultural land or some land out in the country, and I may enter into a contract where I allow somebody to come onto my land and remove the walnut trees that are on there. That would be a profit. There is also what is known, and you don't really worry about these, but an easement or profit appurtenant or easement or profit in gross, and don't really worry about those for that. So, but anyway, so just keep in mind that there are some non-possessory interests that exist in real estate as well. All right. Well, the document that transfers property or interests in land from one person to another or what are known as deeds. And remember, way back when we talked about contracts, we talked about this idea that contracts for the sale of real property need to be in writing, for any number of reasons. And this is particularly true with deeds. I mean, we would have chaos if real property transfers were not somehow documented, in writing and that type of thing. So a deed is a document that conveys legal title to real property, and a valid deed needs to contain these things: the names of the buyer and the seller, words evidencing the seller's intent to convey the property to the buyer, a legally sufficient description of the land, and most pieces of property have legal descriptions, some of which can be pages in length, setting forth markers and boundaries and things like that. If you live in a platted subdivision, it may be all of lot 17 in Manly subdivision 3rd, something like that. It needs to be signed by the grantor, and it has to be delivered to the grantee. So those are the requirements for a valid deed. There's several different kinds of deeds as well. There's what's known as a warranty deed, which again is probably the preferred kind of deed to get. And in a warranty deed, the grantor, the person conveying the property, promises or warrants to the person getting the property, first and foremost, that the person selling the property or conveying the property has title to it, that they have the power to sell it, that there's not any undeclared rights or interests that are flopping around in relation to that land, and that the grantor will not disturb the enjoyment of the grantee in that property. And again, any violation of those things can result in a lawsuit by the grantee suing the grantor. So again, warranty deed is usually a preferred way of getting property. Another deed that I would just mention here in this other list of deeds is what's known as a quitclaim deed. And in a quitclaim deed, that's a deed intended to pass whatever interest or claim the grantor may have in the property, but not warranting the grantor's title, interest, or claim. So, for example, if I sold you the Brooklyn Bridge and executed a quitclaim deed to you, yes, you might be able to sue me for fraud or something like that, but you wouldn't be able to sue me on the basis of a quitclaim deed, because again, all the quitclaim deed says is I'm conveying to you whatever interest I have in this property, and of course, if I have no interest, I'm not conveying you anything. So, quitclaim deeds are oftentimes looked at sort of with a raised eyebrow, and you want to figure out why you would be getting such a document from a seller. A couple other things dealing with the ways to acquire real property. Sometimes you can acquire real property through what is known as adverse possession. So, for example, if I have a neighbor and I build a fence on my property, but through I don't know, drafting error or just because I'm a jerk, I build my fence 10 feet over onto my neighbor's property. If my neighbor doesn't do certain things in certain periods of time, that 10 feet of property becomes mine, and that's what's known as adverse possession. And adverse possession is defined as acquiring title to real property by occupying it without the consent of the owner for a statute statutory period of time. And to get property by adverse possession, the occupation must be actual and exclusive. In other words, I put a fence up around that property. That's pretty clear. My possession of the property must be open, visible, and notorious. So the neighbor sees that there is a fence there on his property and doesn't do anything about it. Third, it has to be continuous. So that fence has to be up there for a certain period of time. Many times that's 10 years. And if I don't occupy it continuously during that period of time, I won't grab it by adverse possession. And then it has to be hostile or adverse. So, in other words, I've built that fence and the neighbor's done nothing about it, and I'm saying it's mine. And again, after 10 years, it could well become mine. There's also a way by which the government can come and take our property, and that's through eminent domain. And we read about eminent domain in the Constitution in some cases. That the government cannot take our life, our liberty, or our property without due process of law. And so the government has the ability to take property that belongs to us. And again, we often see this in cases involving construction of highways and roads, where in order to build an interstate highway or something like that, the road needs to go through somebody's land. And again, the law allows the government to come in and take that land for that public purpose. However, they can't just come in and take it for free. So if the government wants to use property for public use, they have to provide just compensation to the landowner for that particular piece of property. And again, if the landowner and the government can't come to a mutual agreement about how much that land is worth, then the landowner has the ability to go to court. And the issue really is not so much whether or not the land is going to be taken or not. The issue really becomes how much that land is going to be paid for by the government. And so the landowner has the right to due process, to go in and have the property valued and assessed, and then the court can award how much the government needs to pay. So keep in mind that the government does in fact have the right to take your property for public use. All right, a quick discussion of real estate. We will see you again next week. Take care.